Rhode v. Bonta, which is our challenge to the ammunition regulations here in California with Prop 63, is back in the news as we assumed it would be, with the state filing for an en banc review. This is part of the playbook. They want to drag this out as long as they possibly can. Let's talk about it. Hey everybody, welcome back to the channel today. That's right, Rhode v. Bonta has been back in the news after that short while since we saw the last victory from the Ninth Circuit three-judge panel, because as we assumed that they would, the state has decided to file for en banc review. There's definitely some things that are worth discussing in this matter, so to do that, we have brought back on CRPA's volunteer president, that is Chuck Michel. Chuck, thanks for being on with us.
Well, it was a pleasure, fellas. Thanks for having me.
Absolutely. And guys, as always, before we get into this, please be sure to like, share, and subscribe to these videos. It's a great way for you to directly contribute to efforts just like this in Second Amendment litigation and legislative efforts. So please be sure to like, share, and subscribe. It helps the channel, it helps the advocacy, and it goes a long way. So Chuck, let's just jump right into this. For those who haven't been following along, the Rhode v. Bonta decision gave us another victory. We've seen two times at the federal district court victories in this case. Of course, this is our challenge to California's ammunition regulations here in the state since 2016 when they were voted in during Gunmageddon. Chuck, just for those a little bit further who haven't been following along with this, can you go ahead and talk about the path that this case has taken in the court system, which would lead up to where we are now?
Yeah, it's a long, strange trip. It started in San Diego with Judge Benitez, aka Saint Benitez, and he ruled in both our Duncan case, the magazine over 10 round ban, and the Rhode case, which challenges the ammunition restrictions, that we win. Rhode went up with Duncan to the Ninth Circuit, and it was held there while Duncan went through a series of appeals all the way up to the Supreme Court, back down. Rhode was sent back down after Bruen, so they both went back in front of Judge Benitez again. We won again, and Rhode went up to a three-judge panel because it had not been in an en banc panel before, so it went to a three-judge panel. Duncan went right back to the en banc panel, and just a few days ago, a week or so ago, we got a ruling from the three-judge panel in the Rhode case challenging the ammunition sales restrictions, where we won. Now, every time this happens, it's pretty much predictable that the state will ask the en banc 11-judge panel. Remember, we got a win from a three-judge panel. They will ask the en banc panel, 11 judges, to review the three-judge panel's decision. And so we expected that, and they filed their motion for en banc review last week, and so we have a couple weeks to file an opposition to that en banc review, and you can bet we will. We're going to oppose it very strenuously, because the three-judge panel got it right, and so whether we're successful depends on the composition of the en banc panel. So the Ninth Circuit now has 29 judges, I think. So they draw 11 from that whole court, and depending on whether or not we get a strong panel that's not biased against us or progressively inclined, we will win, and can win if they decide to take it en banc in the first place.
I was going to say, let's talk about that makeup of the Ninth Circuit really quick. For a pretty long time there, you kind of had a two-thirds majority of Democrat-appointed judges in the Ninth Circuit. Trump came in like a whirlwind and basically made that 50-50, and then Biden took a lesson and 4 years later made it 66-33 again. It seems like you're kind of carrying the...
It's not quite one-third, two-thirds, but Biden did sneak some judges in there. It's about 45-55 or 60-40. They definitely picked up a few progressive judges, but we still have far more than we used to before the first Trump administration.
Yeah, I would agree with that. But as far as the process of court is concerned, this has kind of been the the
This is
Democrats
their
playbook,
playbook.
right? So they want to appeal to en banc because they have a good opportunity to get more judges that lean against Second Amendment rights than lean for. It seems like you're carrying the assumption that they're going to take it. However, it is not guaranteed. Just like we saw up at the Supreme Court with a couple of the cases like Snope and the Ocean State Tactical case, a process we will have to go through as we're getting ready to file for Duncan at SCOTUS. The Ninth Circuit en banc doesn't necessarily have to take this case, but are you kind of carrying the assumption they will?
It depends on the panel. Well, basically, yes, because it'll be a vote of all the judges, and most of those judges will say they should take it. So yeah, I'm basically assuming that they will take it en banc.
And that defense gets ready. So let's see exactly what that defense is going to be going up against. Jacob, if you could pull this up for me, this is from the appeal to the Ninth Circuit en banc panel by the state, and it reads like this. The panel's decision conflicts with decisions of the court, other courts of appeals, and the United States Supreme Court. As Judge Bybee explains, the panel's Bruen Step 1 analysis is irreconcilable with the court's decisions conducting the meaningful constraint analysis, breaks with our sister circuits, and effectively abrogates Bruen's first step. En banc review is warranted for the independent reason that the panel's decision conflicts with the Supreme Court guidance addressing shall issue licensing regimes and laws imposing conditions and qualifications on the commercial sale of arms. The issues addressed by the panel's decision present questions of exceptional importance, even limited to the context of ammunition background check requirements challenged in this case. They are all the more important because the panel's analysis threatens any law that universally regulates some aspect of firearm acquisition. I guess, it's kind of interesting reading this because it seems like they're not necessarily appealing to the Ninth Circuit, saying that the three-judge panel got it wrong, or that their decision goes against the Constitution. They're merely saying, hey, this opinion disagrees with other courts of appeals, which is a good enough reason to take it en banc. And you and I have talked in the past. That's been reason enough for the Supreme Court to take cases. I'm sure that it's a good reason here. But is it surprising at all, the omission of any wrong opinion made here that in this victory that we got, or is this just kind of run of the mill? This is how you get a case to the Ninth Circuit.
This is how you get a case to the en banc panel. The en banc panel is supposed to take it to reconcile different opinions, not only because they disagree with the three-judge panel opinion, but it's implicit in everything they say that the three-judge panel got it wrong, or we won 2 out of 3 judges. So they're being polite, but they don't, because they know they don't have to be rude to get they don't have to be overly critical to get the en banc panel's attention, to get the attention of the entire Ninth Circuit to decide whether to take it en banc. But they jump on stuff like ammunition is a necessary. You can't, a gun without ammunition is a club, okay? So and the Ninth Circuit has said that in our Jackson case years ago. You have to have ammunition and have a gun worthwhile. Of course, ammunition is protected by the Second Amendment, but they're hanging their hat on a footnote in Heller that said that it doesn't, Heller decision doesn't call into question regulation of commercial sale of firearms. Well, yeah, but there's a big difference between saying that you have to have your gun store in a certain zone, or that you have to have a license, or you have to do a background check, or whatever other restrictions there may be on the purchase of a firearm, where it's an instant check, or in California, a waiting period, but still, it's not as expensive and draconian and as error prone as the ammunition background check law is. So there's nothing, they're trying to use this, it's okay to regulate firearm dealers as a black hole that they can throw any restrictions at the point of sale on a purchase of anything. So that's just not correct. But that's the games they play. I mean, this is not the California DOJ writing this stuff from scratch typically. Bloomberg's lawyers from Everytown Law and are contributing. And then the state spends taxpayer dollars to fight us and come up with these half-baked arguments that the Supreme Court would throw out of hand if we could just get it there. But some of the judges who are inclined to uphold laws will use as an excuse to uphold the law.
Yeah, and we've seen it time and time again. You know, when they realize that they have lost, they try to keep the laws on the books as long as they can, which is why you continue to see appeals, even though it's pretty obvious that they've got the losing case in this. So I guess looking forward to this, I'm also sort of curious what your thoughts on timelines are. I already kind of mentioned, and we'll be doing a video on this pretty soon, guys, because the deadline to appeal Duncan to the Supreme Court is coming up next week. We've seen Rhode and other cases, for that matter, get held up behind Duncan. Do you see a Ninth Circuit? Do you see a world where the Ninth Circuit en banc wants to see what happens with Duncan before they decide to do anything, or do you think that they move forward and continue to produce opinions on this before SCOTUS speaks?
Well, maybe, but probably not, because Duncan says that magazines that hold over 10 rounds are not arms, as that term is used in the Second Amendment to begin with. They're not really trying to argue that ammunition is not covered by the text of the Second Amendment. The right to keep and bear arms includes the right to use ammunition, possess ammunition, acquire ammunition. And then there's a different set of historical analogs that they tried to use in Duncan: gunpowder storage laws and trap gun use bans. You know, all those historical laws are distinguishable. They typically don't ban possession of anything. They ban, you can't set up a trap gun and sit it inside the door of your house and it shoots whoever walks through the door. But you can have one that might use under different circumstances. And they try to use Bowie knives as, the carrying of Bowie knives in certain circumstances was prohibited, but the possession wasn't. So this is the kind of distinctions, but it's a different set of historical analogs that they try to use to regulate, to justify a ammunition background check, when the error rate on those is like 20%. So most of the people, this is what the laws are really designed to do. People try and buy ammunition, they get rejected, and it becomes a project that takes time and money to just go buy ammunition. It's hard, it takes work. And so people, they're inconvenienced by it. They have lives to live, especially folks that aren't regular shooters, and that's what they're trying to do, is discourage people, red tape the right to death.
Yeah, absolutely. So whether this effort to keep this law on the books is exhausted with this appeal to the Ninth Circuit en banc, or if it sees its ultimate end going even further than that, this is one more step up the ladder of the litigative process. I guess as your final thoughts, is there any timeline that can be expected? Are there any dates that the court has to, either decide to take it or not take it? Is there anything to look forward to there with Rhode?
Well, I would expect within 30 days of us filing our opposition brief to the request for en banc, they will decide whether to take it or not. And then it's probably going to be they may or may not order another round of briefing. If they do, that'll take another couple of months, and then there'll be oral argument scheduled a couple months later. So it's probably 6 months or more down the road before we get an oral argument. And believe me, I feel everybody's frustration that their experience as I say this. I mean, the court system is not quick, but the Duncan case is now one of the leading, if not the leading case in SCOTUS, and SCOTUS could clear up a lot of things on the methodology, even though not the specific application in an ammo background check case or any other case for that matter, of semi-auto ban or suppressors or anything else. If they just clarify the methodology, they say that the right to keep and bear arms is expansive. Most things fall under that language. And then the historical analogs that will justify a modern day law, something from 1791 that indicates the founding fathers would have tolerated the modern day law, they have to tighten that up. It can't just be, some law that didn't really do the same thing and for the same reason of that the historical law did. So if they tighten that up, that gives the Second Amendment teeth, and that's what we're trying to accomplish.
So some to look forward to here in the immediate, a little bit more to look forward to even further down the line. Obviously, we're going to be following along with these cases. And guys, if you didn't notice, the state's appeal to the Ninth Circuit en banc panel was that here in the Ninth Circuit, the opinion disagrees with opinions of other appeals courts. And they got it right here in California. That means that these anti-Second Amendment legislative and litigative efforts are succeeding outside of the state of California and outside of the Ninth Circuit. So we definitely want to be pushing for more reassurance from the Supreme Court of the United States to get the Bruen methodology correct so that courts can apply it all across the state, including states like California and New York. Definitely some stuff that we want to get behind. If Rhode's got to go there to get it done that way as well, we want to support that also. But Chuck,
it's a national game. CRPA is monitoring cases all across the country because any case that we win or lose in another state helps us here if we win, and any case that we win here helps in other states. So we can't just play in the California sandbox. We have to look at the national case, all the cases being litigated nationally, because any case from any state that gets to the Supreme Court and clarifies that methodology is going to help us in every single case in California. So it's a historic time. Things are in flux. We are going to win eventually, and the Second Amendment will mean something, and we will be able to use it to restore the rights that have been stolen from us for the last several decades by progressive politicians in California. So whatever folks can do to help CRPA, donate, join. We give great rates to the CRPA. They pay nonprofit prices, and we have lots of people looking over our shoulder about how that money is spent. So it's all done very economically, very efficiently, and frugally. So help us out, and we will keep doing the work for freedom for all of us.
Yeah, and let's not forget, we are winning. The Rhode decision from the Ninth Circuit was a victory for the gun community. The Nguyen v. Bonta case was a victory for the gun community. CRPA versus LASD, Junior Sports Magazine, on and on and on. All of these cases, right. They continue to be victories, and getting backed up by SCOTUS will even increase that. So I didn't exactly want it to be like a dire thing. We have cornered the anti-Second Amendment litigation effort into a corner. They are going to struggle. They are going to do whatever they can to continue with their advocacy. But in this war, we are winning, and ultimately, I think we've got the Constitution on our side and truth on our side and freedom on our side that will enable us to win as well. But Chuck, I do want to thank you. Obviously, we're going to be hitting this again soon as we continue to see things come down in the Rhode case. Obviously, in the Duncan case, we're going to want to talk about that. But I do appreciate you coming on today. Thanks for being with us.
Thanks for having me, guys.
Absolutely. And actually, Jacob, maybe something that we can do is put some links in the description below for some of these victories in these lawsuits. If you guys want a little bit more of an in-depth view, go ahead and click those links. And as always, be sure to like, share, and subscribe. It really helps get this information out there, and it's a great way for you to directly contribute to efforts just like these in the courtroom battling for our Second Amendment rights. Thanks again, guys, and we'll see you on the next one.